So this is the second part of our estate planning fundamental series. So let's start with something really easy that I think everyone understands, and that's the will. I think everyone understands what a will is. Will is a document that talks about what happens to our stuff when we pass away. And most people think that's enough, right? They say, hey, I have a will, it's all covered. I don't have to worry about anything. I don't have to worry about things such as probate. Well, is that true? Well, in the state of California, that's not necessarily true, because if you own $166,250 worth of assets, and those assets are entitled are in your name alone, well, guess what? You're going to end up in probate court. Well, what's wrong with probate? Well, probate takes a long time, year and a half. It's expensive. Estates in Orange County, around the $1 million range, typically fees and costs total $30,000. That's $30,000 that could be going to your loved ones, not attorneys and executors. They're also very public. So when someone's estate goes through probate, it's all information that anyone can get just by walking up those courthouse steps, going to the clerk's office, pulling that file, and finding out everything about you and about your family. And in the age of identity theft, I don't think a lot of people want that. Now, there are some type of assets that you can own, even if you don't have a will, that they do avoid probate. And think of things like life insurance policies or 401ks. Those have beneficiary designation forms. So as long as you go ahead and complete those beneficiary designation forms, and that person that you named actually survives you, then you're fine. You don't have to go through probate. However, the mistake that I see sometimes is that people will go ahead and name estates as the beneficiary of their life insurance, or estates as the beneficiary of their IRA or 401k. And if you do that, guess what? You're going to end up in probate. So we talked about IRAs. We talked about life insurance. Well, what about bank accounts? Well, bank accounts, some of them have beneficiary forms. So if you fill those out, those will avoid probate. Or you can go ahead and name someone as a joint account holder, meaning that when you pass away, that surviving joint account holder inherits the property. That doesn't go through probate. But what about real estate? How do you go ahead and pass real estate without going through probate? Well, you got to be careful with that, especially if you're going to do what I call estate planning through joint tenancy. So joint tenancy works like this. If you have a piece of property, your ownership is represented by a deed, and that deed, if it's held jointly, will say this owned by person A and person B, joint tenants with right of survivorship. So if B survives A, then B gets the property. Here's the problem with estate planning by joint title. So I've gone to many a seminar, and I've had these ladies come up and say, well, I don't have to worry about probate. I've got this house, and I have 4 kids. And here's what I've done. I went ahead and I added my son as joint owner. I added him to title so that when I pass away, the property goes to him, and he's going to make sure that his siblings get their share. Now, do you think that's going to work? I don't think it's going to work. I think you're going to end up in probate court, but we're not just talking about an administrative proceeding at this time. We're going to be talking about litigation. So money, property that you wanted to go to your children, it's not going to go to your children. It's not going to go to your loved ones. It's going to go to attorneys. Now, how do we get around that?